Good afternoon, Realtors. Hope you all had a wonderful Memorial Day weekend. Appreciate you joining us today to go over the new license law changes. So this is a 40-page bill, so we're not going to spend the next 3 hours reading this song and verse. So I've tried to pull out of it the most important parts from today. Certainly at any point, if you are interested in looking at it in full, feel free to reach out to myself or Lindsay, and we can get you a copy of that. I would say, and I'm going to try to take questions at the end. So if you have any questions, I would ask that you hold them until that slide on the webinar. That way they don't get lost. And of course, be mindful that we are in a group setting. So any questions should not be on specific business models, commissions, anything of that sort. And should be focused solely on the license law changes. So a little bit of background and timeline of how we got here, where this license law came from. So in 2022, President Cindy Creamer created a task force of SCR members and staff, as well as real estate commissioners. And the goal of that task force was really to try to find some points of common interest, things that we could agree with them on for strengthening the industry, broker supervision, things of that sort. And so there was a list of objectives that were created from that group. That list of objectives was presented to the Real Estate Commission later that year, and that sort of started the process of working on a license law draft. So in 2023, SCR worked with the Real Estate Commission and Real Estate Commission staff on sort of a draft bill that was presented to the Commission for their approval. The bill 4754 was filed the first week of session this year. And then when that was done, it was supported by our legislative committee and SCR board of directors. Went through the committee process, sub on both sides, full on both sides, working with staff on potential amendments. The bill was actually was passed the last day of session with about 2 to 3 hours left in the session. So right up until the last minute, and it was signed into law and became effective on May 21st, 2024. There are two provisions that we'll speak about that have a later implementation date, but otherwise everything that we're going to talk about today is already in law. That became effective upon Governor McMaster's signature. So a couple things we'll start off with. There are a number of new definitions. A lot of them deal with more on the regulatory side and the commission side. So I didn't want to go through each of those, but there were three in particular I wanted to kind of bring to your attention. The first is the definition of salesperson is now gone. Salesperson no longer exists in license law. That has been replaced when appropriate with associate, as well as supervised licensee, trying to add into the fact that, hey, you do not simply sell things that you are an associate licensee, and that you are supervised, which means that your broker in charge is required for supervising you. You are not just an associated licensee. So there was some expansions to the definition of broker in charge. One thing that is added in there is you will see the word sole, meaning that you can't have multiple brokers in charge, and the broker in charge does not have the ability to outsource any of their duties. Everything the broker in charge is required to do by statute, they must do. You can't outsource it to an office manager, transaction coordinator, team leader. If license law says the broker in charge has to do it, the broker in charge is responsible for doing it. So there are three main categories that those fall under, or broker in charge duties that are put in definitions. The first is the day-to-day management of the brokerage firm. The second is the promptly and rightful accounting of the trust account. And the third is any sort of compliance with license law and regulations. So you are solely responsible for knowing what is in license law, which you are ahead of the curve by attending this today. And then last is the definition of wholesaling. We are going to get into wholesaling a whole lot more in a later slide, but just to start it off with what is wholesaling by definition. Wholesaling is having a contractual interest in purchasing residential real estate from a property owner. So the key is residential real estate. Any of the definitions we talk about in wholesaling in statute apply only to residential real estate. Residential real estate is actually a new defined term in and of itself. So wholesaling will not apply to commercial property. This applies to residential property. So you have a contractual interest in purchasing residential real estate from a property owner. Then you market the property for sale to a different buyer. All this is done prior to you actually taking legal ownership of the property. So if you have a contractual interest in the property, meaning you don't actually own the property yet, but you have a contractual interest, and then you try to actually market the property, something you don't own prior to legal ownership, that is going to be considered wholesaling, which we'll get into a little later of why and how that is not allowed under the statute. So the first thing we're going to cover is some changes to advertising. These are all not involving team advertising. There's going to be a whole nother slide on team advertising. So this involves brokerages and associated licensees that are not a part of the team. So the first is hopefully going to be a welcome change for y'all. I know it's something that I've gotten a few hundred calls on the hotline about. And that is the previous rule that said that you could not advertise another brokerage's listing on social media, even if you had their permission, even if you had the seller's permission. We worked hard with the real estate commission to get that to be changed. And so now in license law, you can advertise another brokerage's listings, but you have to meet a couple criteria in order to do that. The first is you have to have written authorization from the listing brokerage firm. A phone call is not sufficient. You need to have written authorization from the listing brokerage firm to do it. Next, you must acknowledge the real estate brokerage firm in a clear and conspicuous way. Do not make people search for it. Make it very clear who the listing brokerage firm is and that it is not you. And then obviously for the listing broker to give you permission, the seller is going to have to approve of it. That's also required by our code of ethics. Authorization from the seller can be gotten from the listing agreement in paragraph 13. But I would still make sure if I was a listing agent that I had a separate writing where my seller has agreed to allow other brokerages to market their property, because if they don't give you that email, they may be surprised by one of the pieces of marketing and bring issues to you. So if you want to advertise somebody else's listing, you can. You just need to make sure that you have written permission from the listing brokerage has written permission from the seller, and that you give clear acknowledgement of the listing brokerage firm in that advertisement. The next part is sort of a loophole that had previously been in statute and is now sort of been fixed. So you were required under statute, if you were advertising property owned by somebody else, that you had to have your full name of your brokerage firm in the advertisement. But if you simply just wanted to put up a billboard as a licensee, not a broker in charge on I-26 or I-20, you were not required to even say which brokerage firm you belong to, which made it hard for the public to try to find you, to know what exactly you're selling. So that has now been, that loophole has been fixed. So even if you are not advertising property, you are just marketing your real estate services, you're going to be required to have the full name of the brokerage firm in that advertisement. Now, if you're doing that advertisement online, that can be done by having a link in the advertisement to the brokerage firm's homepage, not the licensee's homepage, not the team's homepage, not their Facebook page, the brokerage firm's homepage. I always kind of tell folks, when you want to see what could potentially be a complaint at the real estate commission, go, what is the easiest complaint they could bring? Simply clicking a link and having it go somewhere other than the brokerage homepage is a really easy complaint to prove. So make sure that if you're doing any online marketing, that you have a link to the brokerage homepage. Now, I mentioned there were two sections in which there was a delayed implementation. This has a 12-month implementation, not on the first part of advertising other brokerage listings. You can do that today if you meet those criteria. But as far as having to have your full name of your brokerage firm in any advertising you do, that is a 12-month implementation date. So you have going forward on May 21st, 2025, all of your advertising has to be done that way. Now, if you're advertising property, you still have to have the full name of the brokerage firm, because that was in law prior to the new one. But if you have your standalone marketing materials just as a licensee, there's a 12-month implementation date on that. So make sure, if you're renewing any of your billboards, if you're getting pins, koozies, all that stuff, that you start putting the brokerage firm name on there. So teams. So this is one of the bigger changes to the law. I will let you know on the front end, this is the one that has a 3-year implementation date. So this is the 36-month implementation date for the changes that I'm about to discuss. So all team advertising and marketing must have the full name of the brokerage firm, and the team name cannot be more than twice the size, prominence, or frequency of the full name of the brokerage firm. So if you have a team website and your team team logo is on there 4 times, the broker's name has to be on there at least twice, and it has to be, can't be any more than half the size. Again, really easy things for folks to prove. The investigators just has to simply go around and count, or make sure that it's pretty close. So that's twice the size, prominence, or frequency. That is a new change. That takes away the clear and conspicuous standard that had previously existed, and I guess will be the standard until this goes fully in effect in 2027. But under clear and conspicuous, that left it open to interpretation. You weren't sure what was clear or not clear to one consumer versus another. Whereas twice the size, prominence, and frequency makes a much more objective standard for you to try to meet. Also, team names must now end in team name at the full name of the brokerage firm. So prior to this change, there was the part in statute that said that you couldn't use real estate, realty, or realtors, but that you could, or any other term suggesting a brokerage. We could never get clarification on what that meant. All we had ever been told is that there are the 3 words you absolutely can't have. Team is absolutely allowed, and everything else is a gray area that depends on the facts of the matter. So now it's going to be much clearer, again, going from subjective standards to objective standards. Hey, your team name must end in the word team, and you must have the full name of the brokerage firm in there. Again, you have a 3-year implementation date for that. So the new format, again, is going to kind of look like XYZ team at ABC brokerage firm. All right, long-term agreements. These are some of these 40-year marketing agreements that you've been hearing about. This was addressed in license law. So this is a supplement to S881 that we're going to talk about a little bit later. S881 applied to everyone, not just real estate licensees. A881 also has some civil penalties that are allowed, but this also puts into license law that you cannot do any sort of long-term agreements. So under the statute, any agreement longer than a year is considered bad faith, unenforceable, and grounds for discipline. The agreements can fall into that category if they run with the land and bind future parties, allow for an assignment of service without a consent of the property owner, and or create an recorded encumbrance on the land. So if you weren't aware of these, or if you haven't had the opportunity to deal with one of these, what it was or is a firm will go to a property owner whose property is not for sale and was saying essentially, hey, we will pay you some amount of money up front right now. In exchange, you sign this agreement that says if you sell your house in the next 40 years, you will use us. And if you don't use us, you'll have to pay us some sort of liquidated damages fee. They would then actually go and record that with the county. We had records of those being recorded in every county in South Carolina. And what would happen at that point is maybe the individual who signed that agreement died. They're trying to close out the estate, and now they realize they've got this encumbrance on the land. So this would now, both through license law and through 881, would rule those unenforceable, and 881 allows for you to seek damages and work through the AG's office on those. Now, there obviously are exceptions that were provided that for documents that would require that you obviously would want to have longer than a year. So home warranties, HOA declarations, utility documents, mortgages, assignments of contracts that require longer than a year. So if there's something where you're not sure whether it applies or not, certainly go talk to your attorney. But in general, your listing agreements, your listing agreements and your buyer agency agreements, those can't be longer than a year, but you can certainly renew it. You just on the front end can't say, hey, we're going to sign you up for 24 months. You can sign them up for a year and then renew at the end of the year. That's perfectly acceptable, but it just from the get-go can't be longer than that. And there is something in 881 to allow for property management agreements as well, especially on the commercial side. All right, so wholesaling. Go ahead and start with where, for an easy question. In South Carolina, there are only two ways that you're allowed to market property. The first is the obvious one. You actually own it. If you own the property, your name's on the deed, you can do with it whatever you want with the property. You can sell it in whatever form or fashion you would like whenever you please. The second only other way is that you have to have a written, active listing agreement with the deed holder to market the property. If you do not meet one of those first two criteria, do not take the listing, do not market the property. So marketing property owned by somebody else does require a real estate license. That is now explicitly in statute, especially under the wholesaling section. That if you are marketing property owned by somebody else with the expectation of compensation, that is certainly falls under the definition of real estate brokerage. If you try to help somebody sell a home that they don't actually own, that is going to be grounds for discipline on your end. So prior to taking a listing, I would get a copy of the deed for your file. That is a recommendation that if you've listened to any real estate commission meetings in probably the last 2-3 years, you've probably heard every meeting or every other meeting. So I usually kind of say if there's some advice or guidance that you hear on a regular basis from the real estate commission, that is something I would adopt. So that's a nice, easy compliance thing for you to say, hey, do we actually have, does the person we're dealing with actually have the right to sell the property? It could also be a potential hurdle that a land scammer, for example, would have to clear. So that would be something I would start trying to work into my office policy of requiring a copy of the deed for the file. So again, going back to wholesaling, when the definition of it, when we got at the very beginning, the definition of wholesaling is having a contractual interest in real and residential property, then trying to market the subject property prior to you actually taking ownership of the property. So if you're under contract to purchase 123 Main Street for say $50,000 to close on June 1st, you do not have the right to market 123 Main Street until you close on June the 1st, because you don't actually own 123 Main Street. You can't hold out to the public that you own 123 Main Street. Now, you do have a contract to purchase 123 Main Street for $40,000 on June the 1st. You do have the right to assign that contract. So what does this ban on wholesaling not prohibit? It does not prohibit flipping of the property. So if I buy 123 Main Street on June the 1st for $40,000, I put $100,000 of work into it and I want to sell it again for $200,000, great. No problem whatsoever. That's completely permissible under the statute. This in no way, shape, or form prohibits flipping a property. By the way, I don't even have to put any money. If I just want to flip the property, but I start marketing it once I own it, no problems with that whatsoever. I can assign the contractual right in that contract. So again, I have the contract to purchase 123 Main Street for $40,000 on June the 1st. I could assign that right to somebody else for whatever amount of money, because that is part of my bundle of sticks contractual rights. I have the right to assign the contract. And I could even market the assignment, so long as, and make sure that you are very clear on this, you do not suggest, imply, suggest, or purport to be selling, advertising, or marketing the underlying property. If you do one of those, you're going to be in trouble with the commission. That is going to be a really clear standard, and it does not take a lot for a member of the public to just go, oh, I think I took that to mean that the individual was selling the actual property. I didn't think they were just assigning a contract. So if you have someone who is assigning a contract, it needs to be abundantly clear that they are assigning the contract. You are not trying to market the underlying property. So I wouldn't, things you can't do. You can't take the photos from the MLS of the subject property. That's, you don't have the right to market that property. You don't actually have you don't have a written listing agreement with the deed holder. You're also now stealing somebody's intellectual property by using those MLS photos. So you've got a whole lot of issues there. Don't take your own photo of the house, because again, you don't have the house to sell. You have the contractual position of the house to sell. So I think one of the times the commission has taken this up, they said, your advertisement wouldn't be a picture of 123 Main Street. It'd be a picture of the front page of the contract for 123 Main Street. And again, if you're using the SCR contract and you're going to do a change of a buyer or a seller, that's going to be a change that's going to be required for both parties to sign off on. But for no other reason than in paragraph 4, we put who the deed is recorded in the name of. If the property's been assigned, surely that's going to change. So if your client's ever wanting to get involved in assignments, that is something they're going to need to speak to their attorney about. But wanted to make clear what wholesaling is and what it is not. The commission has had multiple task forces on wholesaling, has been working on a guidance document for it. So this is something they are laser focused on. So if you're not sure of whether you're doing something right or not when it comes to wholesaling, give us a call on the hotline or just steer clear. All right. Broker in charge duties. So this is something that was added in, new stuff that was added in. One of the biggest issues we've seen and the commission has seen has been the lack of broker supervision in the state. So again, you are as broker in charge, you have the sole responsibility for everyone underneath your license. That is, they fall under your name. You are responsible for everything that they do. You're responsible for every document. Again, I remind folks when I do my classes, individual licensees do not have clients. Brokerages have clients. So any document that the individual licensee signs, they need to be doing it with your permission. You as broker and under broker's policy can decide which documents you can and cannot allow associated licensees to sign. But even if they sign it without your knowledge, you're going to be responsible for it because it happened under your watch. So you cannot outsource or assign any of these duties that are assigned to you by a statute. If you agree to be a broker in charge, then you have to do all those duties. You can't outsource that to somebody else. One thing that was added to try to add for more broker supervision is now going to require 5 years for you to become a broker in charge. There was no grandfathering of that. So if you will need to take all the education, but instead of 3 years of experience, it now requires 5 years to become a broker in charge. And one of the biggest changes for a broker in charge is that you will now be required to attend any disciplinary hearing of an associated licensee, of a supervised licensee. If you fail to show up, that is actually something you could be sanctioned for. And the sanctions that were added for that were pretty steep. So that's more important to have in your office policy. Hey, if one of our licensees is contacted by the real estate commission about a potential case, they need to let us know so we can start working with them. We can maybe get brokerage counsel involved, because I'm going to find out for sure, because I'm going to get the formal notice when it goes through, and now I'm going to be required to attend. So if I'm going to be required to attend for a hearing, I would like to maybe get involved in the process earlier to see if I can try to mitigate it, maybe provide more information, etc. So you will be required to attend that. There's not going to be a whole lot of latitude for you not to be able to be there. So a couple other noteworthy changes. Again, this was a 40-page document, so I tried to kind of hit the high points and certainly see what questions y'all have. One thing that was added is the time period for a license moving from lapsed to canceled is now going to be 24 months, as opposed to it was previously only 6. So difference between going from lapsed to canceled. If you were lapsed, that just means you can't practice real estate. But if you renew within the 24-month period, you just have to go back and take your CE, but you don't have to start from scratch. If you're canceled, you got to go all the way back to school and you got to take your initial pre-licensing courses. So that was now an extension to 24 months. So something you may not have been aware of, in the previous statute, there was never a requirement for when the offer rejection form was due. It just simply said that you had to provide one. So in theory, if a complaint had been filed against you for failures to turn in an offer rejection form, and upon hearing that complaint, you had sent the offer rejection form, you had kind of at that point been in compliance with statute by the time of your hearing. So to get rid of that loophole, an offer rejection form is now due within 48 hours of that rejection. So now, again, a more objective standard. If your offer was it's the easiest way to think of this is 48 hours from when your offer expires. If your offer has not been countered or accepted, then that offer rejection form is due. If it's more than 48 hours from then they're not in compliance with statute. Brokers you are now responsible for following up on trust funds, even if it's at a law firm. So just saying, hey, well, we don't hold the earnest money, so it's not our job to figure out whether or not the client turned it in on time. It's with the law firm. That is no longer allowed, even in statute. It is explicit that your job as a brokerage is to follow up on those funds. So the recommendation I make is have your licensee, when they take a contract, look at the date that the earnest money is going to be due in paragraph 5, and then make a calendar invite for that next morning for them to email the escrow agent and ask about the funds. And that's whether they're representing the buyer or the seller. That way, if they're representing the seller, they can tell their seller, hey, the funds aren't in, maybe we can terminate. If they're representing the buyer, they say, why isn't the money there? You need to get that as soon as possible. The seller could terminate. And now you've also got a paper trail should a complaint be brought up on this. The statute previously had a couple things that you may not have been aware that there was actually a benefit for non-residents, where non-resident licensees got to take less education. They got more carryover. The commission has essentially worked with it and went through and eliminated all those distinctions. So licensees are all now essentially treated the same. One thing hopefully you'll be excited about, you will now have the ability to carry over up to 4 hours of elective CE to your next renewal cycle. So if you've ever been in a situation where you're like, I want to take this CE class, but I've already done all my CE for the year, you would now be able to take that class and carry it over. This would not be for your core course or your broker course, but you could take, in theory, you could take 6 hours of elective and carry some of it over. You could take 4 hours of elective and carry those extra 2 over one renewal cycle. And then lastly, I think we may be one of the first states to do this. We now have artificial intelligence language that's been added to the statute, essentially stating that you are responsible for whatever work product is produced in your name, whether or not it's been produced by you or AI. Simply saying, I didn't write that, the AI did, is not going to be a defense. You are responsible ultimately for everything that happens under your name. And as a broker in charge, you're responsible for everything your licensee does. So you're not only responsible for what your licensee does, you're responsible for what your licensee's AI bot does as well. So 2 other bills that we worked on this year I wanted to touch on briefly. 881, again, that is the general prohibition on long-term marketing agreements that I discussed earlier. So this is in addition to what's in license law, but this applies to the general public. So it prohibits the recording of those agreements and deems them unfair if they meet those criteria we discussed earlier. It provides for legal remedies should you be harmed. The AG's office is the one who is the running point on this. So if you've had any affected clients, I would certainly encourage them to contact their attorney to see what remedies they would have available to them under this statute. And then lastly is the Appraisers Act. This is something SCR has been working with the Appraisers Board for about 2 to 3 sessions now for them to do their practice act, get it in compliance with some federal regulations. The reason we get involved is because of the exemption that is in their act to allow for us to do our members to do BPOs and CMAs. In the past few years, there's been a difference of opinion on what the term value means and whether like an RPR report is an appraisal or tries to be an appraisal. So we have worked with the commission, with the Appraisers Board, with their staff, with the legislature to try to find a fix that works for everyone. So it is, you need to make abundantly clear if you're doing one of these that you are not, it is not an appraisal. I would go as far as when you send it to somebody, BPO for 123 Main Street, parentheses, not an appraisal. And the more times you can work that in there, the better. Hey, this is a BPO, this is a CMA, I'm not trying to do an appraisal. That way, if the Appraisers Board does try to claim that you were doing one, you've got all that built-in stuff there. Now, there is something that you are required to use, is required anytime you do a BPO or a CMA. You must have the language I'm about to show you on there. So if you are doing this for a bank, make sure the bank has this verbiage on there. If they don't, do not do it, because that is a hard and fast. You are required to have this verbiage on there. You are required to say that this valuation service cannot be used for the purposes of attaining financing in a federally related transaction. That needs to be done. Again, I would put that in my email as well. I would make sure that that phrase was plastered everywhere that I'm doing one of these. If you're doing an RPR report, if you're doing a BPO, you're doing a CMA, make it abundantly clear to everyone involved that, hey, this is not an appraisal. This is not something you can use for federally related transactions if you're obtaining financing. But this is, BPO CMA, which and here's the benefits of me doing one of those. That is perfect. Those are allowed under statute, but you want to make sure you're clear on that with anyone that you deal with. So that was sort of an overview of the high points of license law and the other two bills that we worked on this year. And this is the first, class that we've kind of done on the license law. We are going to have, Lindsay is going to have a video giving a legislative update, and we're going to have a legal podcast as well. We will try to clarify some of these questions that y'all have had on here to the best of our ability. If I did not get to your question, please email me. My email address is austin@screaltors.org. I'll make my best efforts to get back to you in a timely fashion. But I wanted to make sure that the first group that we reached out to with this was the brokers in charge. Since this law was signed into effect by the governor last week, wanted to have you guys be aware of it. And again, if there's ever anything we can do at the state association to help, any answers we can provide, certainly let us know.